Okay, good afternoon. Thank you all for joining us. This is the post-lunch, more or less, panel where people are digesting, but it's going to be very interesting. I'm going to introduce our panel, and we're just going to have a discussion of some very interesting issues. I'm looking forward to it. I am Professor Maya Steinitz. I teach at the University of Iowa College of Law. One of my main areas of research and expertise is litigation and law firm finance and the future of the legal profession. And I'm also an arbitrator. Our first speaker today is going to be the Honorable Judge Peck. And of course, I can't do justice to people's full biographies, but Judge Peck served for 23 years as a United States Magistrate Judge for the Southern District of New York, including a term as a Chief Magistrate Judge. He is now a DLA Piper, where he advises on innovative and efficient solutions to the challenge of information management, both within and outside the legal context. He often speaks about or is often retained and serves as a special discovery counsel. He has been described to me as the e-discovery guru, and he has written some of the earliest landmark decisions in this area. We also have with us today Janet Sullivan, who is the e-discovery counsel and global director of practice technology at White & Case, where she leads the litigation practice technology innovation for the firm. She's responsible for transforming the firm's in-house e-discovery operational model, which focuses on the tactical implementation of industry-leading technology to achieve cost savings and strategic advantages, and was recently recognized for the excellence of her operation by the Financial Times. And she also has 20 years of experience as a trial attorney. And last but not least, we have David Horrigan, who is a discovery counsel and legal education director at Relativity. He's an attorney, an award-winning journalist, and former legal technology industry analyst. He served as counsel at the Entertainment Software Association, reporter, and assistant editor at the National Law Journal, and an analyst and counsel at 451 Research. So we're here to talk about e-discovery and civil procedure, and we will start off with some remarks by Judge Beck.
All right, well, I am told, having missed the morning, that some of this may also have been covered by the first panel, but it's sort of a history of discovery in 30 seconds, of the days before we were in e-discovery. No, I was not practicing law when people were writing on stone, but amazing concept to some of the students, I'm sure. People wrote memos and letters on paper. They mailed them, and when one had a litigation and one had to go do discovery, you went to the client, and generally it was something like, okay, where are your documents about the ABC contract that's now in litigation? And, a few chief executive types would have some files that their secretaries would keep for them. And then there would be the common file and the maybe accounting records. And then, of course, there were the boxes upon boxes, usually unlabeled or close to unlabeled, in the warehouse that we were told probably have something on it. And of course, our stories about going to the warehouse, the temperature was minus 20 degrees or 120, depending on the season. The rats were the sizes of alligators, and, it wasn't quite that bad, but it's much more colorful that way. And the two big innovations, first, for those of you who may be doing any discovery work, you may have heard of Bates numbers on documents. Now they're generated into the system by the computer, but it came from a man named Mr. Bates, who came up with this stamper that would have the numbers on it, and when you stamped one page, it would automatically advance to the next number. What a great innovation, and lawyers and paralegals would sit there mindlessly stamping away. And of course, the biggest innovation of the 1980s in document discovery was when 3M came out with the Post-it notes. So you can stick your note on it, and if it was in the upper right-hand corner, it meant privilege. If it was in the lower corner, it meant produce, or whatever it may be. But it may have been difficult, and you had to look at documents, but the volume was mostly, in most cases, something you could readily wrap your hands around. Once we got into the computer era, and we put this E before the word discovery, the volume has gone up exponentially. And the ability to have an associate at a law firm actually review every single document, which was the so-called, erroneously considered gold standard of the paper days of discovery. And it was the standard because that's all there was. There was no technology to help. That doesn't work when you're dealing today with cases where you may have 1 million or more emails. And that's without even talking about how now emails have become almost as old-fashioned as letters. And we have to think about texts and file shares and Dropbox and disappearing messaging apps and all of those things. But in one of the prior discussions, talking about one of the things that slow down innovation is because many senior partners still think, when I was a young lawyer, the best way to do it was to have associates reviewing every document, and that just isn't true. It is not the gold standard. Hopefully we will keep you awake after lunch today, but computers don't get tired. If you're using computer-assisted review, predictive coding, TAR, whatever acronym you want to call it under, once the system knows what it's looking for, it is never tired, it is never distracted, it is not also going onto a second computer to bid on something on eBay or whatever. So that's sort of the history of discovery in 2 or 3 minutes.
Jenna, do you want to tell us more about the history, or would you like to take us to the other end of the spectrum and tell us about some of the most cutting-edge issues?
Sure, or maybe I'll just combine a little bit of the two on that. I'm reasonably certain, and I agree wholeheartedly with Judge Peck as one of those persons who actually was stamping documents and putting Post-its on things. But it's unlikely that anyone spends their time thinking about going to law school, spends 3 years in law school with all the money and cost and time that's associated with that, takes a very rigorous licensing exam to pass the bar to practice law, to say, what I really, really want to do with my law degree is sit in a room in front of a computer and click save next, and a radio button that says responsive. So it's unlikely that that's really an aspirational goal for any one of us. And so technology, it's absolutely correct in terms of the gold standard is no longer a lawyer's eyes on every single document, since with the proliferation of emails and so on and so forth, electronically stored information, 80% is garbage, not relevant to your case, and 20% might be. But what lawyers do want to do is look at the 20%, look at the maybe 6% or less of those that are actually hot documents or really germane to the case, and have those inform your legal opinions, your legal arguments, and your defenses in the case. And so what we're sort of talking about is not so much the threat to, let's say this junior associate work and maybe, not being able to learn. I don't think anybody's thinking I've learned an awful lot by hunting and pecking and, clicking a button to save to the next one. What they have learned from is actually looking at the relevant documents. So to the extent we can take the hunting and the finding of those relevant documents, setting aside the not relevant documents, and focusing the young lawyers on learning on how to analyze what, guess by the way, might actually be evidence at your trial, that's where I think, electronic discovery, technology-assisted review has really come into play and really come to the fore. So it's not so much taking away a true skill, a true value add that was traditionally had by, first or second year associates, as it is sort of refocusing the finding of those documents, and leaving maybe that to the machines who are better equipped to say, yeah, this is not relevant. This really is based on training from subject matter experts, and then repositioning those associates to actually understand how what will be evidence here in your case informs your legal argument. Getting back a little bit to e-discovery and what is e-discovery, and we've heard a lot about, so is it discovery, is it e-discovery, and the whole process and things. I would submit that e-discovery really isn't a thing. It's a process. It's not a one-time, this happened. It's a series of events. It's a marathon. It's not a sprint. And the interesting thing about e-discovery is that, and Judge and the other panelists will certainly talk more about this, is that through the course of that, it is a bit of a minefield. We like to look at rules of civil procedure as a roadmap. I think that's the kind way of saying in some ways it can be a minefield. And so, it really will be very important to understand the devil is in the details in those rules, but it is a marathon, and it's a marathon that necessarily requires you, particularly in this day and age with electronic documents, to really think about the end at the very, very, very beginning. So just when you're starting your new matter, you've just talked to the client, you've got this matter in, it's a global client, maybe there's data in country A and country B and country Z around the world. We're talking now not about terabytes of data, but petabytes of data. Maybe there's been an actual global incident that's impacted your client, and you need to think quickly and you need to move quickly. And at that point in time, you're supposed to be figuring out, okay, what am I going to do about the metadata in this? What kinds of documents, what kinds of electronic file types am I going to have? Where are all the data sources? Was there WhatsApp? Was there an internal Jabber? Does this deal with Bloomberg chats? What are all the panoply of possible data sources that we have? And so it is a bit daunting to think that at the very beginning of a matter, when you go to your meet and confer, you really need to have thought about, okay, at the time when I want to produce this data, what am I going to need to do to identify it and collect it first? And so I won't bore you with the technical aspects of that. I probably couldn't even if I wanted to try. Who are we kidding? But I will say that it is a bit of a chess game in that you do have to be thinking 10 steps ahead. And then the last piece is just this notion of the fight within the fight. And it's called civil procedure. And as lawyers, we have ethical duties and to behave in a professional manner. But at the end of the day, as a litigator, and I'll take one of the other panels here, recovering litigator and trial lawyer for 25 years. Clients hire us to win. They hire us to win those matters in an ethical way and in a proper way, but they do hire us to win, and sometimes winning means just getting a better settlement, and sometimes winning actually means going to trial. But at the end of the day, civil procedure and e-discovery can be the fight within the fight. So there's the fight on the merits, the actual legal aspects of the case and the underlying matter. And then there's the fight about what you did or didn't produce and why you didn't and how you did it wrong and why you should have and what you didn't do. And I'm sure David and Judge will have some very interesting stories to tell us about sanctions in Rule 37 and where that all fits into play. So I would say as much as it is a roadmap, it can be a minefield, so something to keep in mind.
Great. Janet, you've given me an opportunity for a shameless plug because you mentioned that it is, after all, called civil procedure. Perhaps there should be some civility in it. But I am actually the host of a podcast, and Judge Peck has been one of our guests, entitled Uncivil Procedure. And sadly, that happens more often than not, but we'll get to Rule 1 and the alleged cooperation initiative in a minute. But I learned many years ago that one dissents from the learned opinion of the Honorable Andrew Peck at one's own peril. If one is going to shoot at the king, one had better not miss. But I've got to dissent respectfully only on one point you mentioned, and that was that it wasn't that bad in the paper days. And like, we're all embellishing. Sir, we are not. We were doing one production in law school where the moral of the story is the litigant had annoyed the judge, and Judge Peck can tell us that is something you never want to do. If you take nothing else from today's presentation, that's an important lesson to learn. But so they had angered the judge, and the judge said, all right, you were going to be set for discovery no matter what. and you have got to have it by next Wednesday. And they're like, we can't do this, Judge. It's physically impossible. You cannot get commercial office space. Oh, yes, you can, because the judge forced them to rent out the luxury boxes of the NFL Jacksonville Jaguars suites. And so we got to kick back there, but there were no documents because they had not been found. And so we were paid, when you're a law school student, you thought enormous rates to live in Jacksonville, Florida, and sit in the luxury boxes and do nothing because they had mangered the judge. Well, it gets worse for everyone involved because the documents finally do arrive. They are paper documents, and they are filled with brown recluse spiders. They are literally carrying out lawyers and law students and paralegals on stretchers. I thought, oh, who's afraid of spiders? Well, you know what? Guess what? If it's a brown recluse spider, be very afraid. But those sorts of things happened all the time, and then we moved on to the first world problem of the paper cut, and many law school students suffered through that, and now we're all have degenerating eyes, and we need glasses and all of this. The process really has improved, but it's changed dramatically, and part of the reason is that computers are doing a lot of the jobs that lawyers used to do, especially there used to be full-time review lawyers, and that was their job. They went from project to project, and they made more money than anyone in their law school classes. And they threw away that old adage that, well, the A students become law professors, the B students become judges, and the C students make all the money. Because a lot of times they weren't at the top of their classes, but they made the most money. And how they did it is because a lot of these e-discovery contract lawyers got paid overtime. So they had no lives. I mean, they worked 100 hours a week, but no associate has a life. And so the e-discovery machine went through and through and through. But I give a lot of guest lectures at law schools, and the one thing I always tell the students is, if you're in an e-discovery class, you're in the right place. Because one of the things, if you take something away from today's talk, is how has legal technology affected civil procedure, is that if you are a techno-lawyer, you are a very valuable commodity. Just last month, I was moderating a session with a head guy with one of the legal staffing agencies, and we were trying to see how many of 100 questions we could answer in 10 minutes. And we got through a lot of them, and the general theme coming through is, you don't have to have a PhD in computer science, but if you know the technology, these guys can get you jobs. Now, if you're at Harvard Law School, you're probably not going to have a problem getting a job anyway. But for everybody else who isn't at Harvard Law School, it's some pretty good news, and it's a real way that change is really affected. And Judge and Maya and Janet, do we want to get into, as long as we're talking the history of how the 2006 amendments were supposed to make the world safe for e-discovery, not unlike World War I and the democracy, and only to have them amended later?
E-discovery and democracy, that's a great topic. No, we've talked about how e-discovery has changed civil procedure. Let's talk about how civil procedure is shaping e-discovery, and that's the change to the rules. So I don't know, should we have the judge
Sure.
start us off?
All right. So the first of the modern changes was the December 2006 amendments, where the concept of ESI, defined electronically stored information, came into the rules. Previously, the rules just referred to documents, and then there was a definition floating around, probably in local rules, not the federal rules, that documents includes computer something or other information. I don't know, but it was a very inartful form. And in 2006, using the same structure of the rules, but incorporating this concept of it now applies to ESI, that was the innovation in 2006. And the smart thing that the Rules Committee did then is they were technology agnostic. Some people expected them to say, documents and emails, or documents and word processing documents and emails. But no, they kept the definition of ESI on the assumption that it is a very difficult process to amend the federal rules. It doesn't happen that often, and therefore, we, the rule makers, want to be able to cover everything. Another way that applied is one of the struggles at that point was companies that had backup tapes which were mostly designed for disaster recovery. If your main premises and your computers there were bombed or, under a flood or whatever, you had backup tapes off-site a day behind the current operations or whatever, and then done monthly, quarterly, yearly, whenever it was thought that you might need to recover your entire system. And one would have thought those would get recycled, and when you had the next backup, you would delete the prior, but no, many companies just had stores and stores of backup tapes. But instead of referring to how to deal with backup tapes that were hard to access, the rules talked about documents that were not reasonably accessible. Again, so that it could cover any sort of technology. That really was the big innovation or the change in 2006, having the paper-based rules now apply with some shoehorning to electronically stored information. The next major change in the federal rules, and this is probably taking some of you back to your Civil Pro days, Civil Pro 101, but the next major change in the federal rules dealing with the vast volumes of ESI were now, we're talking almost 4 years ago, December 2015, when a lot of the rules were restructured because of the bulk of data. So with, Rule 1, which is the overriding rule, was changed then to insert the concept of cooperation much more. Interestingly, the advisory committee could not get the word cooperation actually into Rule 1. It's in the amendments. The advisory committee notes to Rule 1, the language change in Rule 1 itself is that the rule should be construed, administered, and inserted now, employed by the court and the parties to secure the just, speedy, and inexpensive determination of every action. So lawyers are supposed to cooperate. Do lawyers cooperate? From my experience, both on the bench and now for the last year and a half when I've been back in harness as a practicing lawyer, as with any other answer by a law professor, lawyer, or judge, it depends. Some lawyers do. Usually that's when the two sides are symmetric. In the asymmetric cases, as Janet was sort of talking about, e-discovery can often be the satellite torture by the plaintiff, let's say, in an employment discrimination case where he or she has virtually no data. The company has all the data, so e-discovery is used to impose costs on the company in the hope that that will lead to a settlement. The statistic, by the way, less than 1% of civil cases in federal court actually ever go to trial. The rest get decided on motion or summary judgment. So often, what is happening in the discovery process is as close as one is going to get to actual trial. So it's sort of trial by combat in a different form. The other major change in 2015 was to move the concept of proportionality that was in the rules. It was sort of buried in 26B2C Romanet 3, and for some reason lawyers and judges didn't read that far or whatever, so this big deal was that moving proportionality up to 26B1, the definition of what is discoverable. So it has to be non-privileged, relevant to the claims and defenses in the case, and proportional to the needs of the case, with 6 factors for determining proportionality, including costs, obviously, but also including the importance of the issues in the case. So, for example, again, going back to an employment discrimination case where Congress has determined, in the old days when Congress was functional, that employment discrimination was bad and that there was a public policy of allowing those suits in federal court, even if there wasn't a lot of money involved. So issues like that, or civil rights cases, things like that, you don't just look at the money. But it brought proportionality back into focus, and that is one of the big issues in discovery now. You know, how many millions of ESI documents must one go through before it becomes disproportionate to the needs of the case, et cetera. Another big change, because it was driving all lawyers and particularly judges crazy, and David is right, if Rule 1 is cooperation, Rule 1/2 is don't piss off the judge. It doesn't do you any good. And one of the problems was the way lawyers were answering discovery requests. So there would be, requests for all sorts of documents in ESI, and there would be pages upon pages of general objections. We don't like your definitions, we don't like your time frame, of course, we're never going to produce privileged documents, et cetera. And then in response to each particular request, it would read something like this. We object to this request for all of the reasons stated in our general objections. In addition, we object that this request is overbroad, burdensome, vague. We don't understand the English language words in it. And yes, for those few lawyers that updated their boilerplate, they now throw in, and it's disproportionate to the needs of the case, et cetera, pause, period. Without waiver of these objections, we'll produce what we damn well feel like when hell freezes over or the court instructs us and orders us to do it. Now, I've taken some liberty with it, but other than the hell freezes over part, in any court today, they don't have to file document requests and responses, but in every major law firm, despite the rule change, you will still see that. Hopefully, at DLA, we see it only in opposing counsel's responses, but I can't guarantee that despite my training of our associates and partners, that we're not guilty of that as well. So 34B2 responses was specifically amended to say you must respond with specificity, you must indicate whether any documents are being withheld on the basis of an objection, and you must indicate when you are actually going to produce the documents, because the usual response wasn't quite hell freezes over, but we will produce the documents on a rolling basis, and then you never know when the documents are coming or if they've started coming, when that is going to end. So yes, even when a firm is doing a rolling production now, one is supposed to say, we will start our production on X specific date, and we will finish by Y specific date. That amendment, old habits die hard. Too many lawyers ignored that, either because they didn't know the rules had changed, and I do find lawyers think the rules are whatever they were taught in Civil Pro 101 and don't think about amendments no matter how long ago they went to law school or how recently, or because the younger lawyers coming out of Harvard and elsewhere know that the rules changed and you can't do that, and when they drafted a document response in the proper way and showed it to the supervising partner, he or she said, but this doesn't have all the usual stuff we put in, go to the firm file and use it. But, I said use it. Okay. So there are any number of judicial decisions that got fed up with that. I was one of them. So if you are, as you start your career, looking for a case to use against an adversary who's violating that, my decision in Fisher versus Forrest said, it's been 2 years since the rule amendments, get with the program. And I basically said, as a wake-up call to the bar of the Southern District in New York, you keep doing this in front of me, and I am going to say that you have waived all of your objections except to be a semi-nice guy, I said, except for privilege. Okay, we'll deal with privilege, but everything else, do it right. There are any number of other opinions. Mark Bennett out of your home district of Iowa had a similar decision, et cetera, et cetera. You can probably find one in every district that you're going to be practicing in. Finally, of the major rule changes, Rule 37 dealing with spoliation and the sanctions for spoliation. The prior so-called 37E safe harbor said that if information was lost because of the normal operations of a computer system, then sanctions wouldn't be imposed. The problem with that is the case law had developed to say that once litigation was reasonably anticipated or began, you have to take steps to put in a litigation hold and shut off any of the automatic deletion functions in email or other things. So the old safe harbor wasn't particularly safe. So 37E was now amended, and if we were using slides, there's a really great complicated flow chart that you could find online that Eric Mandel designed, and it's available one way or another through the Sedona Conference website.
But Judge, all that gobbledygook is wonderful, but can't you just take 37E down to 3 words they inserted, intent to deprive, and call it a day?
Not quite.
All right.
Almost. And thank you for the setup there. But there are 3 parts of 37E. So this is a little bit of law professor geeking out that I'm going to play with here. The first part is the preamble, and it has various conditions. So it says, if electronically stored information that should have been preserved in anticipation or conduct of litigation is lost. So that's the first steps. 1, this only applies to ESI, not to paper documents or other physical material. 2nd, should it have been preserved in anticipation of litigation? If the information was destroyed long before litigation was a gleam in anybody's eye, you're fine, and you don't have to go any further. But if, after litigation was reasonably anticipated, information was lost, then you look at the next part, because a party failed to take reasonable steps to preserve it. And as Jean and some of the other earlier panelists said, it is reasonableness, not perfection. But if you didn't take reasonable steps, and that's why it is incumbent upon corporations and their inside and outside counsel, as soon as you are served with a complaint or as soon as somebody threatens litigation, you got to take reasonable steps to preserve information that may be relevant to that. Okay, so if the party failed to take reasonable steps and it cannot be restored or replaced through additional discovery. So if, now that backup tapes tend to not be, these mysterious items that are unindexed, et cetera, if there is another way to get at the data and restore it, replace it, you're fine. No sanctions, no problems. All right, so assuming all of these triggers have been met, then there are 2 paths. So 1, if there is a finding of prejudice to the other party from the loss of the information, the court may, and it's may, not must, order measures no greater than necessary to cure the prejudice. So that's the mild remedies. Maybe it's ordering an additional deposition. Maybe it's ordering you to go to data sources that otherwise it would not have been proportional to go to. But it's a question of, can the information be restored through some other means, or are there other means to cure the prejudice? Maybe it's saying a particular witness cannot testify, whatever. And then, and David gave the magic words, box number 2, upon a finding that the party acted with the intent to deprive the adversary of the information's use in the litigation, the court can do heavy sanctions. So dismiss the case if it's the plaintiff that's spoliated, order an adverse inference or a default judgment if it's the defendant. That finding of intent to deprive can get interesting. If you start reading judges' opinions, and basically in the first paragraph it says, and immediately after being ordered to produce their laptop, the party ran Evidence Eliminator, a great product with a great name for marketing. But when you see it mentioned in a lawsuit, someone is going down and is going to be seriously sanctioned. But it's a product you could buy at Best Buy or whatever the local electronics store is. And it is, in most cases, there isn't that, and certainly it should never be by the lawyers as opposed to the clients. But it is amazing how many cases there are with, my laptop, it fell in the river, and then I ran it over with my truck, and there was a lightning storm, and my backup systems were destroyed. The stories you get from reading these cases are quite amazing. But more cases are in that preamble or E1 docket. It's not an intent to destroy, intent to deprive, it's negligence, stupidity, and then the question is, what do you do to even the playing field?
Thank you so much. We've covered a lot of ground. Janet, you're welcome to either comment on that, or if you want to take us in a different direction and talk about privacy laws and how they intersect.
So maybe I'll just piggyback on that a little bit to say, rewind to, so now that we've heard about Rule 37 and the sanctions, and we all clearly understand, how we have to advise our clients in terms of the preservation obligation, what's reasonable, what's proportional. So how do you do that? How do you do that with a client that has a global footprint, a $60 billion, financial portfolio, offices all around the world, and you need to now figure out how to make sure the fella in Dubai shuts off that auto-delete function on a jabber that somebody might have, in an office there. And as outside counsel, it's your obligation to make sure that happens. So it seems like this seems very simple. Obviously, we're going to make sure that we preserve things. It's a reasonable standard. But as a practical matter, it isn't always that easy. So what do you do? Really important, and again, I'm not going to go into the weeds on the technical aspects of things, but really important that your inside counsel is working very, very closely with their information governance specialist and with the client's IT. Very critical at the very beginning, when litigation is reasonably anticipated, that all those stakeholders are on the phone. And so it's not just the general counsel, it's not just the legal parties, and they can certainly advise you on who the business unit owners are, but it has to be IT from the client side, and it has to be their information governance person, so that you can, because I can assure you, when it comes time, if there's a dispute over what was deleted or what might have been discarded, a good lawyer is going to ask for a deposition of that party's information governance person. Please produce your retention policy. I see. And so this was your retention policy, and either why wasn't it adhered to or why wasn't it suspended? What do you do in the case of a litigation hold? How do you handle those? So my advice would be to make this in any way manageable. Make sure you have all the client stakeholders invested as soon as possible.
And I would say that if you are the corporate stakeholder and you are holding a lot of the data and you are a nefarious spoliator, the new Rule 37E is your friend, because this intent to deprive standard really makes things difficult. And to set the stage for you, the clamoring for this basically came from the defense bar. And the idea was, look, we are having to preserve until the cows come home. We are having to do defensive preservation, and we're wasting money only because of the threat of litigation. So the idea is, all right, you shouldn't be punished for an honest mistake. We're going to insert this intent to deprive standard. Many groups were up in arms over this, public interest groups, the plaintiffs' bar, left and right, because, and I think that former Judge Schindlin, a retired U.S. District Judge, one of Judge Peck's colleagues from the Southern District of New York, probably articulated it best when she said, look, if it's negligence or gross negligence, that still means the evidence was gone and that party is prejudiced. You shouldn't get off the hook just because you didn't do the right thing and you didn't mean to do the right thing. And basically she said, such a standard encourages sloppiness. Now, what you really get into is that if you get into these 37E sanctions, under these amendments, you really get into a question of how do you show this intent to deprive? And the criminal bar has to do it all the time to establish the mens rea of a case. But if you look at, and this is Deflategate, we're in Cambridge, so let's talk about the New England Patriots. That case started off as an arbitration, but Tom Brady made the argument that destroying his mobile phone was the good faith operation of a computer system because he and Giselle were celebrities. Therefore, under advice of counsel, they always destroyed their phones. Yeah, well, it probably changes the rules of the ballgame a bit when your phone is something that has been requested in a document request of an ongoing investigation, but that's neither here nor there. But you get into these situations, Judge Peck mentioned these various dog ate my homework stories. Taylor Swift is another one. The gentleman who surreptitiously recorded the conversation in the Taylor Swift case had coffee spilled on his MacBook. He had a backup, and miraculously, the backup fails as well. And once again, in neither one of these cases was an intent to deprive found. And you have a lot of judges and a lot of courts saying that, my hands are tied. I have talked to some judges who are just itching to give sanctions to a well-deserving, nefarious spoliator. Can't do it because you can't show the intent to deprive. So that has really made a change.
Interesting. Thank you, Judge Peck. I'm mindful of the clock, and we want to leave room for questions and answers. But would you like to tackle one of our remaining aspirational topics, either privilege and the rules of evidence, or talk to us a little bit about TAR?
All right, let me, both are my favorite topics, but okay, I am going to send you all out into the world with a great rule that nobody knows about. So in 2008, the Federal Rules of Evidence were amended. Indeed, this amendment had to go through Congress because their Commerce Clause powers were necessary. And to make up for the volume of data, it is what I have called the get-out-of-jail-free card. In every massive document production, privileged documents, no matter what technology you're using, no matter how careful your secondary review by associates is, some privileged email is going to slip through. Federal Rule 502 was enacted, and 502D allows the court to enter an order so that if a privileged document gets out in the litigation, it is not a waiver. So 502D says a federal court may order that the privilege or protection is not waived by disclosure connected with the litigation pending before the court, in which case it is also not a waiver in any other federal or state proceeding. Now, that's very important in situations like product liability or other cases where there is, the first few lawsuits and then a lot of follow-on lawsuits in federal or state court. So if you have a 502D order, and it's not automatic, you need to ask the court for it, put it in your protective order, put it in your ESI protocol in order, get the judge's signature on it. And if you get an order under 502D, and I've got standard language, again, we're not using slides, but if you Google Judge Peck and 502D, you will come up with the order I used on the bench in any one of 12 other places, but the good old Google will get it all to you. And it basically says the production of privileged or work product documents, ESI or information, whether inadvertent or otherwise, is not a waiver of the privilege or protection, in this case or any other federal or state proceeding. This order shall be interpreted to provide the maximum protection allowed by Federal Evidence 502D. And then I've added a newer sentence that says the provisions of Rule 502B, as in boy, do not apply. And I don't have time to go into that now, but there was a case under 502E that used 502B and basically eliminated the protection that one would be getting. Technology-assisted review, and I will just do this in 1 minute. I'm looking at the clock. Hold me to it. Technology-assisted review, also called TAR or predictive coding, is the use of AI to help in the review of ESI for production. It is much better than associate review or other eyes-on review. It is much better than keywords, which is the thing that people went to limit the population that has to then be looked at by anyone. For those of you who, use Pandora or Spotify or buy from Amazon, it is the technology they're using. So on the music services, if you say, give me a Billy Joel song, and you give that a thumbs up, it'll then suggest, how about Elton John's such and such song? If you give it a thumbs up, it learns more and more about your musical interests, and then it throws in a heavy metal song, and you say, not a chance, thumbs down. And that is sort of the way training goes for the algorithm. In a particular case, it's how the computer under TAR learns to use the knowledge from a subject matter expert or experts, and it is great. The case law, at least the two major cases on it were ones that I wrote. So in DaSilva More, I said that it's okay to use predictive coding. It was the first case that went that route. And by a few years later, in the Rio Tinto against Vale case, analyzing all the other cases, I said by now it is black letter law that if the responding party wants to use technology-assisted review, the courts will allow it. If you're further interested in the case law, and yeah, I blew the 1 minute thing, but it's like the lawyer in a deposition or court that says, just one more question, Judge. That's always 5 questions. It's never one question. Anyway, go to the Sedona Conference website. The Sedona Conference is a 501c3. It is one of the major think tanks in the e-discovery sphere. And a few years ago, we published the Sedona TAR case law primer that analyzes all of the predictive coding TAR cases. I have abused my minute, so I apologize.
Concluding remark, Janet?
I'll make 2 quick points piggybacking off of what the judge had said on that caveat on the get out of jail free on the Federal Rule of Evidence 502 is if you happen to have a young associate at a deposition who uses that privileged document, then you're going to be back in jail. So no longer jail free on that. And on the TAR predictive coding, we heard a lot today about adoption and use. And I can tell you that, in many years ago when predictive coding was first out on the market, it was like, this is going to be it. It's going to be a no-brainer. Everybody's going to be using it. Why hasn't it really taken? And there's, TAR 1 and TAR 2 and various models, and the technologies sort of come along. And some of the reason for that is it was new and change is hard. But some of the other reason for that is that it did require a fair amount of investment up front in training the tool. So just as the judge alluded to Spotify, where you're teaching it, I like country music, forget that heavy metal. Same thing with responsive documents. And who has to do that? Subject matter experts, outside counsel, probably higher level folks who are reasonably expensive for the client. And if it takes 50,000, 60,000, 70,000 documents to train the tool, even though the long-term benefit is clearly there, there's a bit of impatience both on the part of the client, and then with some documents, if they're not necessarily a rich set, or if the reason for responsiveness could be date-related or individual-related, so that the conceptual analysis and textual analysis that the machines go through is not readily apparent, so the tool doesn't really work that well. After you've spent all this time and investment, a lawyer needs to get burned only once before they decide this thing doesn't work. That being said, and Judge Peck alluded to this in one of his more recent, I believe it was Rio Tinto, is that the technology has improved, and now we have continuous active learning, meaning that you don't even have to worry so much to front end all of this loading. You can have the machine learning in the background as you have your lawyers reviewing, as you have this continuous learning model, re-index every night, bubble up all the responsive documents so that the lawyers are getting those and continuing to learn. You'll get that heavy metal document in there every once in a while, and the lawyers will say, that's a no-go. And so it's a much less painful process with a much less front-loaded cost and expenditure and time investment. And as a result, it's being used in a lot of ways, not just to cull data sets, but for quality control. Some lawyers and clients still say, nope, eyes on every document. That's still great. You can still do that. We know the documents at the very end are going to go quickly. Maybe you put your more junior associates or contract lawyers on those documents, and you use it for quality control. So now on quality control, let's just look at the delta. What's the difference between the machine thought this document should say or be coded, and what's the difference between what the lawyers did, and you can get through them much more quickly. So.
Thanks. I would add with Judge Peck, one thing, he may be being slightly modest. His DaSilva More decision in February 2012 was somewhat groundbreaking because that decision really changed the road mark. Because before that time, lawyers like, wait a minute, I got to make this 26G certification that we're producing everything. How can I do that if only the robots have looked at them? And before, no one wanted to dip his or her toe in the water. And before you had a decision like DaSilva More saying, we can do it. And following us were Ireland in the Quinn case and the United Kingdom in the Pirro case. Excuse me, so far we've been the only three, but the proliferation of this technology.
Australia?
Australia, you think that counts? Well, no, it wasn't a no disparagement to the Australian courts. It was not a court decision. It was a practice rules. But I guess that's fair enough.
Decision too.
But not the language wasn't as strong as yours. Yours, but anyway, all right, we'll give them Australia as well. And we love Australia. Let's just state that for the record. But getting back to the Peck poll, the rule on 37D, that is your get out of jail free card. If you are Larry the litigator for Sally the spoliator and you have negligently failed to follow Judge Peck's excellent advice, 502B can possibly save you because you can then go to the court after you've made this mess of your client's case and show a three-pronged test. Was it inadvertent? Was, as the holder of the privilege, did you take reasonable steps to preserve it? And three, once you made the error, did you take reasonable steps to rectify it? The problem is this is a waste of your time, and that means it's a waste of your client's money, because if you'd just gone to Judge Peck in the first place, you wouldn't have even had this problem. As far as technology-assisted review goes, it really has changed the rules of the ballgame, and Judge Peck had a lot to do with that. For instance, I don't talk about my company's software that much, but they're software platforms other than Relativity that can do this, but you take what would have taken a room full of associates, paralegals, and contract lawyers to review. You can do a confidence level on there and notch it down. And the ubiquitous Enron documents from the Enron scandal in the early part of the last decade are there because allegedly they've all been scrubbed for personally identifiable information, but you can go through there. And for instance, one of the documents was the Lay family, the CEO's family, planning for their dinner at Le Cirque in New York City. If you've been able to dine there, I will quote Ferris Bueller and paraphrase him at least and say, if one has the means, I recommend it highly. If there was a document they didn't want to be seen, this is it. These poor people have lost their life savings, the company's going belly up, probably through malfeasance, and you're organizing the family dinner at Le Cirque. Well, you turn that confidence level to a 90%, and then you're going to get documents that maybe, or you've got a 90% confidence level that are related, and you pull up on this corpus of documents the employees going to a La Madeleine restaurant for lunch. Like, oh, I get it, Le Cirque, La Madeleine, French names, eating, okay. Then you crank it down to 80%, so you're going to get more documents coming in. And then you get some employees going out to a Mexican restaurant by the Astrodome in Houston. And so it's amazing what you can do. And it used to be you had to make the decision, do you go to a jurisdiction such as India that had the big three, English-speaking, common law, and a relatively low cost of doing legal work. Now they call it inshoring because you can bring it into a place that's not Boston or New York or Los Angeles on the coast. You inshore it to cities such as Lexington, Kentucky, where you've still got very qualified lawyers who work at a very much smaller pay scale, and the real estate, the office spaces are much smaller. So when you think, gee, how does this legal technology and how has e-discovery changed the rules of civil procedure? Massively, and it's been a two-way street.
Thank you very much. We have some time for a couple of questions, so anybody from the audience?
Don't be shy. I no longer have contempt powers now that I'm off the bench, so come on. Kat, thank you.
Do you think that the adoption of advanced technology, which has taken such a very long time since the DaSilva More ruling, is going to accelerate based on the ease of use that the newer iterations have? And kind of what's your wish go forward in terms of adoption and use of AI?
You know, I once said at a panel like this that I thought that TAR would really take off when there was a newer tool that was better. But putting that joke aside, I mean, there is more use, a lot of which is what I would say is sort of behind the firewall. The parties go out and negotiate what keywords they're going to use, which is still the old-fashioned way, and they do that. And then there are enough documents that they hire a vendor, and the vendor says, by the way, we've got this TAR or other analytics like it built into our software. Do you want us to do that so that even though we're looking at the documents hit by the keywords, at a minimum, we are going to bubble up the most relevant documents to you first, and then when you get down to the back percentage that is most unlikely to have any relevance, you can stop review, or as Janet said before, go to a low-level fast. And I'm seeing more and more of that now that I'm back in private practice, that as a judge, I had no way to know. So I do think it's being used that way. I would still like to see more of it being used instead of keywords or openly. And part of it is, as one of the prior panels talked about, cost models. You know, the more you save money with technology, the less profit the firm is making.
So, Judge, I'd be interested to have your thoughts on disclosures, because I feel like some of the squeamishness around using this is that there's still a little, and maybe you'll disagree with me, but there's still a little uncertainty as to what you may need to disclose if there's a dispute over what was produced and what wasn't produced and what was withheld. Would you have to disclose your validation set? Would you have to disclose your methodology, your training sets? And those of us who are very old school, who were in the warehouses figuring out whether we wanted to look at box on row A or box on row Z, are thinking, that's work product. You would never have been able to discover that. I'm not going to tell you why I chose to look at this set of boxes over that set of boxes. But a lot of the underpinning of your decisions, Judge, is based on transparency and disclosure. And so maybe you could...
Sure. You know, I think with what we're now calling TAR 1.0, simple learning, where one had to train the system, and once it was trained, that was it. The computer would then rank everything. You know, the old computer saying garbage in, garbage out, the other side wanted to know how you did that training, which led to all sorts of fights about what would be in the seed set, and did you have to show the non-responsive documents from the seed set as well as the responsive. That has been eliminated with continuous active learning. So there's less of that. And I said in Rio Tinto that I thought it was unfair to hold TAR to a higher, statistical model standard than one would do with keywords or the old-fashioned eyes-on review. And I am seeing more looking at null set statistic issues, even with keyword production. So we're still in that area where people don't trust each other. How much, cooperation is great. I still believe in it. One of the bedrocks of the Sedona Conference was the Sedona Conference Cooperation Proclamation. On the other hand, there is also work product and Sedona Principle 6, which is that the producing party is in the best position to determine how it is going to find the responsive documents. You know, lawyers should not be willing to put their license at issue. As David said, by signing the document responses are certifying under 26G of the federal rules that they have done a reasonable job. There is always going to be fighting, and I think we are now at a level where the fight can be about keywords as well as TAR, so maybe, you know, in that reverse logic, that will help get TAR adapted.
Thank you very much. I'd like to thank the panel, thank the audience, and I hope you've learned as much as I have.